first matter to come before the court this morning is Heidi Carroll versus Robert Kinney. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, I'm keeping the clock this morning and can keep you apprised of the passage of time. We've read the briefs and we're ready to proceed when you are.
Thank you, Your Honors. May it please the Court. My name is James Lane. I'm here representing the appellant Heidi Carroll. If allowed, I'd like to reserve 3 minutes for rebuttal if possible. As the Court knows, we're here today on an appeal of a denial of a domestic violence petition, or civil protective orders petition. The core issue, I believe, Your Honors, in this matter, as it is often in domestic violence cases, is do you believe the victim's testimony? And if so, do the acts as described by the victim amount to domestic violence? In this matter, I would say absolutely the acts described by the victim, which is the child in this matter, amount to domestic violence. And the evidence presented in this matter overwhelmingly should have convinced the trial court to believe the child's testimony. That testimony came in through 4 separate, distinct witnesses, 3 of whom were strangers to this child. Specifically, the child's testimony was that his father picked him up and dropped him on a table, injuring his arms, and that his father was angry when he did so. Now, those specific statements were remarkably consistent through the child's statements to 4 separate adults, all of whom testified in court, all of whom testified specifically about what the child said to that adult. And the testimony of those 4 adults was remarkably similar as to the statements of the child. Specifically, those 4 adults started with the child's mother, Heidi Carroll. She testified that Christian, the child, told her unsolicited on September 19th, 2014, that Daddy was very mean, that Daddy had picked him up and dropped him on a table, and that as a result he had hurt his arms. And he went on to explain further what happened. After that, Heidi took the child to see a school counselor, asked the child to see a school counselor at his school. That school counselor, Dr. Barlow, Tula Barlow, met with the child, asked him what happened. The child said the exact same thing. Dad picked me up, dropped me on a table, hurt my arms, showed the bruises, which were described by the treating physician as significant bruises. Told the therapist, Dr. Barlow, that Daddy was mean. Daddy was mad at him. From there, the Department of Jobs and Family Services, caseworker Emily Justice, met with the child. Again, exact same story. Daddy picked me up and dropped me on a table. That's how I hurt my arms. And this time, Emily Justice asks him, because she does what some other folks don't want to do, understandably, is they don't want to lead the child in anything, but it's her job to ask, are you scared to go back to Dad's house? His answer, yes, I am scared. That was her uncontroverted testimony. The 4th person, and probably the most important person that this child told his story to, was the treating pediatrician, Dr. Emma Reisman. She testified, and she just so happens to be board certified in pediatrics and board certified in child abuse, in detecting child abuse, in treating child abuse. She testifies the exact same story, which is the child came to her, brought by mother, and she asked what happened. Child says to her, Daddy picked me up, dropped me on a table, that's how I hurt my arms. Daddy was mad because I wanted a Lunchables. Same story the child told to everybody. 4 adults, 4 separate occasions, the child is saying the exact same thing. So the issue becomes, I think the evidence is overwhelming that this is what happened to this child and this is how he was hurt. There is no evidence to controvert that at all. When father testified and asked what happened, no explanation whatsoever. He has no idea what happened to this child. He offered no explanation. And I think by that, we know for sure it wasn't an accident. Because certainly, I'll be the first to admit, and my client would be the first to admit, kids get hurt accidentally all the time. And if it was an accident, all we had to do was get into court or just call her and say, hey, I'm sorry, I wanted to let you know, Christian tripped and fell on a table and hurt his arms. No big deal, he's okay, but this is what happened, I wanted to let you know. That's not what he said, that's not what he testified to, that's not what he did. His position is, I have no idea what happened. He didn't fall by accident. Instead, what he testifies to, he goes into court and says, and admits on cross-examination, my child is truthful. And historically, when he's explained how he's been hurt, he's told the truth. So by his own admission, the child is likely telling the truth here. And he has no explanation as to how this injury occurred otherwise.
Counsel, what
Sure.
are we going to find in the record regarding any objections to the testimony of the 4 witnesses that you referenced as it relates to hearsay or any other objections?
Those objections are there. So I think there was a long discussion, and it goes over multiple pages, I can recall, as to whether or not the statements of the child should have been offered into evidence. I would argue that they come in several different ways, and it depends on who is offering the testimony. But I would also say that that issue has been waived at this point, that the trial court let it in, and Mr. Kinney chose not to file a cross appeal on that issue here. So if he has any complaints about hearsay coming in, that issue has been waived at this point.
When you say the trial court let it in, did the trial court make a ruling on those objections?
They did. Basically, they ruled that the testimony was admissible, I believe, under Rule 807. That's my recollection. So specifically in regards to the testimony, it is uncontroverted that this is what happened to this child. So the next question obviously has to be asked, does this rise to the level of domestic violence? I would say absolutely it does. The statute specifically says domestic violence is defined as attempting to cause or recklessly causing bodily injury. So whether or not he intentionally threw this child down onto a table in a fit of anger, or he did it recklessly, even playing with him, that's domestic violence. And if it was an accident, all he has to do is come into court and say, yeah, we were horseball, an accident happened, he fell and hit his arms. He didn't say that. So that's not what happened. Obviously what happened here is at a fit of anger, he threw this child down. That's domestic violence. Then you add into it, that's just one incident. We have other incidents as well. There's strong evidence that this child suffered bodily injury. There are pictures of bruising on this child, which is very significant. Bruising on his arms from the September incident. Further, and probably even more significant, was bruising that occurred on December 27, 2013. The child came home with significant bruising on his back and bruising on his arms in the shape of fingers. Like somebody grabbed his arms very hard to cause bruising. Those pictures were shown to Dr. Reisman, who is a child abuse expert. Her testimony was that that bruising caused her significant concern of abuse because it was not the type of that was not the type of bruising which is likely to happen as a result of play. Her testimony was that bruising to the back is very uncommon as an injury from play, and the finger-shaped bruising on the child's arms is extremely uncommon to be a play or accident injury, but it's extremely likely to be an injury as a result of abuse. Dr. Reisman's testimony, I believe, was extremely important in this case. Mr. Kinney, in his brief, would have the court believe that because she did not define by a reasonable degree of medical certainty that this child had been abused, that her testimony had no value. I think nothing could be further from the truth. Obviously, in child abuse situations or in domestic violence situations in general, rarely are there eyewitnesses. Rarely do you get definitive evidence as to what happened. Domestic violence almost always happens behind closed doors. It's almost always circumstantial evidence. Her testimony was extremely powerful on these issues. She examined the child, she interviewed the child. After examining the child and interviewing the child, her testimony was that she suspected that Christian was a victim of child abuse. And that's on page 76 of the transcript. She testified that she believed that his statements were not coached by anyone. And that's on page 48 of the transcript. She testified that his statements about the causes of his injuries were very consistent. She asked him multiple times what happened. He was very consistent throughout his testimony. She testified that the bruising on his arms was consistent with the child's story and was unlikely to be caused by a child's play. She described the injuries to his arms as being significant, both in her testimony and in the medical records which were offered into evidence.
Counsel, could you speak to the issue of the court's finding that the trial court's determination that it did not have jurisdiction to modify parental rights because a portion of the case had been appealed to this court?
Yes, Your Honor, and I think that was a clear error. And I'm not sure if it was because I did not read from my interaction with the magistrate, I did not take it to be as a result of the appeal that it didn't believe it had jurisdiction, though that was cited in the decision. My feeling from my interaction with the magistrate that it was more because there was a pending child custody case there as well. Either way, it's an error, because Civil Rule 75H is very clear that the trial court has jurisdiction to make child custody decisions during an appeal as long as it doesn't interfere with the appeal, which it very clearly could have.
But you were asking that any modification to child custody would occur during the DVCPO process, right?
Yes.
Okay, and there was a finding of, it was dismissed by the magistrate.
It was dismissed.
And because of that, would that divest the court under that case to have the authority to change custody?
Well, the trial court, and when the magistrate had the jurisdiction, and I specifically told the magistrate this, and she disagreed with me, that it had the jurisdiction, regardless of an appeal, or regardless of the fact that there was a child custody case pending in the same court, that because it was the same court, she had jurisdiction herself in the domestic violence proceeding under the specific domestic violence statute to temporarily modify the allocation of parental rights. She disagreed with me.
I thought, didn't the child not see the father for 42 days or something?
Right, that was as a result of the ex parte order.
Right.
But her position was, and this is what was written in the decision, was that as a result of 31-13-31, she took the position, and the judgment entry that the judge eventually approved this in full, was that the trial court never had jurisdiction to modify allocation of parental rights. In the case law, as I read it, I found nothing that is in any way challenges this. The case law, and it's specifically in regards to
Counsel, you're reaching into your 3 minutes of rebuttal.
Sure. Okay.
Go as you like or reserve as you like.
Sure. Case law is very clear. This court had jurisdiction to modify the allocation of parental rights. It chose not to do so. And it was also an error to dismiss this case. It should have been denied or granted. It dismissed it with a reference to the finding of Department of Jobs and Family Services, which it should have never even considered because it wasn't offered into evidence during the hearing. Beyond that, there's no basis for dismissal unless there's a lack of jurisdiction, improper venue, or failure of service, none of which were present here. So this case should have never been dismissed. It should have been denied or granted. And the fact that it was dismissed is also a clear error. There's 2 clear legal errors here, aside from the substance of the case. The 2 clear legal errors are the fact that the court claimed it didn't have jurisdiction, which frankly colored the entire proceeding. That was the magistrate's position from the moment we walked in the court was, I don't have jurisdiction, I don't know why you're even here. She specifically said that. Why are you in my courtroom? I don't have jurisdiction to do anything. So we're facing an uphill battle from the second we walked in there. The position of the court was, there's no reason for you to even be here because I can't do anything for you, which wasn't the case. And I explained that to the magistrate in the court. Didn't want to hear it. And then beyond that, this dismissal based upon what Department of Job and Family Services does, that's completely irrelevant. The trial court has a statutory mandate to hold a full hearing, consider the evidence, and rule on that evidence.
So is it your position that the court, I know your position in the brief was that the court pretty much abdicated its decision-making, but is it your position that the court should not have considered the report along with other evidence?
Had it been admitted into evidence during the hearing, I think it's one fact amongst many that it could have considered. And had it been offered in the testimony and properly authenticated and then subject to cross-examination, all of which it wasn't, had that happened, it could have considered that fact.
Did the writer of the report testify at the hearing?
She testified, but at that time, they hadn't made their decision. It wasn't until 2 or 3 weeks later that that report was submitted to the court. So that was never subject to cross-examination. It was never authenticated.
Was the writer cross-examined on her testimony?
There was no writer. So the only person that testified was Emily Justice, a caseworker. At that point, no one had written a report. And the only thing that was submitted to the court was the sort of standard form that says, this is our determination, with no actual author. So I'm not sure who actually wrote it.
And counsel, I need to inform you, you utilized your entire 15 minutes. Thank you for answering the court's questions.
Good morning, Your Honors. I'd like to start by Andrea Burdell-Ware for Rob Kenny. I'd like to start this morning by directly addressing counsel's first statement to you, that the core of this matter is, do you believe the victim's testimony? It's core. That's what counsel said. And the biggest problem with this, which is why the case, a good part of why the case was lost, is because the victim never testified. Counsel admits it's core. It would have been a very, very important piece of this case. They chose not to bring in the child to testify about these alleged incidents. Counsel has argued that the statement...
Well, I understood his opening statement to mean what was the credibility of the witnesses who did testify. So you've got mother, you have all these other witnesses. Was their credibility called into question?
Their credibility, I will direct this court's attention to their credibility, but I just wanted to address what counsel believed is core, and I would agree that it was core that the victim needed to testify directly in this manner. There was nothing offered as to why the victim didn't testify, couldn't testify. There was no hearing held on that issue. The petitioner simply chose not to try her case that way, and certainly that is her right to do so. It wasn't my right to change that. I didn't have the ability to change. I wouldn't change it. It wasn't my burden. It wasn't my case. I had to defend it, not prosecute it. Counsel also indicated that the child statements were consistent. We hear this repeatedly. My position, having been in the trial and listened to everything, is the only thing consistent about the child's alleged statements is that they were inconsistent throughout each witness's account of the child's alleged testimony. With regard to that, first I would address the fact that we were not required, as I understand the law, to file a cross appeal on a case we won to address whether or not the court considered statements. That is not my understanding of the law. To the extent they appealed the case, I have the right to argue that the testimony and evidence presented had problems as it related to admissibility. And I am arguing that here today. Let's talk about the witnesses. The first witness they called was Emily Justice, a social worker. She was not present when the alleged incident took place. Her statements of what the child supposedly said included Dad lifted him, that, quote, it sounded like he fell into a table. These are the witnesses' testimony. That the child couldn't give any other details like it was playful or what provoked it. So admittedly, their first witness is unable to add any credibility. There's no trustworthiness. There's no reliability to these child's out-of-court statements. And likewise, there's no reason that these child's statements are admissible. Ms. Justice was specifically asked if she provided the information she obtained to a doctor for medical purposes, treatment, diagnosis. She specifically said she did not do so. They were not obtained for that purpose. So they are excluded under both 803 and 807. With regard to Dr. Barlow, their second witness, Dr. Barlow, her version of the child's story is also, again, that the child was picked up and then dropped and then hit a table. Interestingly, though, Dr. Barlow says that the child's injuries went around the child's arm. She is the only witness that says that. The doctor who looked at it and examined the child never said that. Dr. Barlow, the child's counselor, says the marks are some sort of prints like pulling or tugging or something along those lines. There's not even any picture evidence of that. I mean, Dr. Barlow's version is completely not credible. You can discredit it for the fact that she didn't even see what other people supposedly saw. She also testified that the only purpose in speaking with the child was to make sure it was okay in school. She specifically said she did not investigate the mom's allegations because it wasn't her job in the matter. She just wanted to make sure that the child was okay in school.
Regarding that place and time, the brief on page 6 says the bruises Ms. Carroll alleged as abuse were not even on the child when he was dropped off at school on the morning of Friday, September 19th, the day Ms. Carroll claimed to first see the bruises.
Correct.
I'm confused. Are we talking about two sets of bruises, and how does is it Friday that the people, that the witness who was at the school sees the child, or is it a later day? What's the record?
That's a very good question. Thank you. Mom alleges that she sees the bruises on the 19th, which is a Friday. The child was at school, but no other person at school reports having seen these bruises. The first time that Mom takes the child to see somebody is Monday or Tuesday. I believe it's Dr. Raisman sees the child either Monday or Tuesday, so it would have been 4 or 5 days after Mom reports having seen. But nobody at the school saw these bruises when Mom says they existed. Dr. Barlow...
Okay, before we go forward, but what's the parenting time schedule in relationship to this period of time?
Dad has the child on Wednesday, Thursday through Friday morning.
Okay.
And then the child goes to school. The child goes to school all day long. Then Mom picks the child up from school later that afternoon.
So did Ms. Carroll drop the child off on Friday morning?
No, Your Honor, Mr. Kenny dropped the child off because it would have been the end of his parenting time in the exchanges at school.
Okay, because the statement is, the bruises Ms. Carroll alleged as abuse were not even on the child when he was dropped off at school on Friday morning.
Yes, Mr. Kenny testified that he dressed the child that morning like he does every morning, and there were no bruises that morning.
Okay.
So Ms. Carroll alleges that she sees them on September 19th that evening. Dr. Barlow doesn't come into contact with the child until the following Tuesday. Interestingly, Dr. Barlow testified that she reported that the child told her on page 88, he told her about his dad, that he was told to tell her about his dad. She testified on 103 that his response was not typical and she felt the child was coached. Moving on to...
But Dr. Barlow, I mean, you just said that the injuries, you said that she spoke to the child to make sure that he was okay at school. There was really no other purpose for her to look at this child, really. But she did make a call to Children's Services, though.
She said she had to based upon the allegation. She didn't say that she investigated for truthfulness because she's a mandated reporter. Any allegation whatsoever, truthful, not truthful, she has to report it. It's not her job to investigate, and she did so. That is what she did.
So this is based on what the mom told her, not what the child told her?
That's unclear from my understanding of the record. The child was specifically instructed, she believed the child was instructed to go in and tell her what the father, what he said his dad did. With regard to Dr. Raisman, it's the child's pediatric doctor, and she is not a stranger to the child. She had seen the child on several previous dates because it is his regular provider. She alleges that the child said he got hurt. Arguably, the statements do come in under 803 medical exception. However, 807 they don't come in under. I don't think we have to go there. She alleges that she asked for a demonstration of how the child got the bruises, and he slammed his arms onto her examination table. She then said, though, that the child said, "Dad dropped me," but after further inquiry, the child said he fell. The child was never interviewed without mom being present ever, though he could have been. And the doctor was specifically asked if she interviewed the child outside of mother's presence, and she indicated she did not, but that she could have. The doctor also testified on 26 that it's hard to know what a 6-year-old means when he says he was dropped. The doctor herself admits she can't really know what the child's statements mean. The doctor says she couldn't tell with any degree of medical certainty how long it takes a child's bruise to appear. There was a line of questioning about, well, if a child was impacted on a day, a particular day, how long would it be before a bruise appeared? She couldn't say. She said it depended on too many things, and she didn't have any information about that. She said it depended on the impact, it depended on what the child supposedly hit or hit his arms on. She couldn't identify where the bruises came from, or if someone or something caused them. She couldn't identify if they were accidental or otherwise.
What's the age of the child?
6 years old, Your Honor.
At the time?
At the time.
Thank you.
You're welcome. The doctor then confirmed that the size of the bruise on each arm was the size of a dime. These are the allegation of abuse is because there's a bruise the size of a dime on the child's arm. She testified that not every dime-sized bruise is reported as abuse. In fact, she testified that she has never said that before, that a dime-sized bruise is evidence of abuse, but that because of mom's story, she reported it.
Well, okay, so I think I follow your argument that because of the size of the bruise, that perhaps that goes to the fact that it was not a serious injury, but the fact that they were bilateral also cuts against some kind of accident.
Well, Your Honor, I would submit to you that if you fell on something and blocked your fall, you would have symmetrical bruises, but that is not any testimony or evidence. But
Not the same as the dime-sized bruises, though.
well, we don't know. The doctor said she couldn't test. She would have no idea whether it was an accident, whether it was intentional. She said she couldn't tell anything other than she could report what she saw, which was a dime-sized bruise. That's what she was able to tell.
And what about that taken together with the testimony of the other, I'm not sure if it was Dr. Barlow, who said that the bruises looked like pulling marks on the arm?
Well, Dr. Barlow's bruises said they went around the arm. They just didn't. Dr. Barlow's story is just not accurate. It's not credible at all because that's not what any picture shows. Mom doesn't testify to that. No other person in the whole case does.
And did I understand you to say that there are no photographs of bruises before the trial court?
No, I said that there's no bruises that go around the child's arm.
But my question is, will we see in the record photographs of whatever was there?
Well, Your Honor, I moved to exclude all of the petitioner's evidence based upon the fact that it was not offered before the close of trial. That was not ruled upon. So I would move again that those should not be included in the record based upon that, but that is this court's determination, I suppose, at this point.
Well, if my understanding is that if a motion is made and the court is silent on it, it's deemed denied. So that would mean that the matters would be before us.
In which case you, in fact, will see pictures.
Okay, thank you.
You're welcome. With regard to the Dr. Raisman here, interestingly, petitioner admits the doctor's medical records. There's a big, long thing about why they should go in or not go in, and I lose, and the child's medical records are admitted, and the child's medical records indicate that there is no obvious signs of abuse or neglect to the child. That's page 68 of the testimony. She also testified on 71 she couldn't tell where the bruises were, how they were formed, or that mom herself didn't cause them. What's important, one of the big things at trial was these bruises supposedly happened on Friday the 19th. Mom, an attorney, a licensed attorney, claims that she couldn't do anything, she didn't do anything because she just didn't know what to do. Mom is a mandated reporter. So mom now wants to claim, she comes to the domestic relations court and obtains an ex parte CPO the following Tuesday. So mom's claiming it's child abuse, but mom doesn't report it when it happens. Mom spends the whole weekend. She spends Friday, Saturday, Sunday, Monday, and Tuesday before she gets a CPO. She doesn't call the police on Friday or any part of the weekend. She said she didn't know she could. She doesn't take the child to a doctor anytime during that. She doesn't communicate with dad. Mom testifies that she realizes that dad's not going to have access to the child over the weekend, but yet she still doesn't ask dad, hey, what are these bruises from? Did you see these bruises? She doesn't inquire at all because she's trying to tell us that she's afraid for her child if she tells dad. Dad lives in another city. Dad doesn't have any parenting time at this point, and then she goes and obtains an ex parte CPO. She canceled the child's dentist appointment that would have occurred during that period so that dad wouldn't have access to the child or know about the allegations. You have to have a little background, and it comes out during the trial in the transcript that this case has been going on for years and years and years.
And counsel, I regretfully also need to inform you that you've utilized your entire 15 minutes of time.
Thank you, Your Honor.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the Ohio Supreme Court website. You can link to that website also through the 9th District Court website. Thank you.
Thank you.